Welcome to Pursuing Quality Long-Term Care, an educational podcast for individuals needing long-term care and their families. Join us as we talk with national experts and advocates about strategies you can use in the pursuit of quality long-term care. Guardianship is a tool intended to support individuals who have lost the capacity to make decisions for themselves. However, guardianship is an extreme step and can have a devastating impact on a person's well-being. In this episode, we will discuss guardianship over residents of long-term care facilities, less restrictive alternatives, and strategies for supporting residents under guardianship.
Hi, welcome to today's episode of Pursuing Quality Long-Term Care. I'm Lori Smetanka, Executive Director of the National Consumer Voice for Quality Long-Term Care, and we're really glad to have you with us today. For today's episode, we're talking about guardianship on residents of long-term care facilities and the impact on a resident's life when they are under guardianship or being threatened with guardianship. And our special guests today are Alison Hirschel, who's the Director of the Michigan Elder Justice Initiative, which advocates for older adults and people with disabilities through legal assistance, policy advocacy, and long-term care ombudsman services. And also Emily Miller, who is the managing attorney of the Crime Victims Legal Assistance Project of the Michigan Advocacy Program, a statewide civil aid team focused on providing free legal assistance to survivors of abuse, assault, neglect, and exploitation. So Alison and Emily, welcome. So glad to have you both with us today.
Thank you.
Thanks.
Glad to be here.
So this is such an important topic and one that we hear a lot about. I know you certainly do, and we do too at the Consumer Voice. And so I'm really glad we're talking about this today. So let's just start by, Emily, maybe you can get us started by talking about guardianship, explaining what it is and what it means for an individual when they're under guardianship.
Yeah, absolutely. So guardianship, which is also in some states called conservatorship, is a court proceeding where a judge will determine whether someone has or does not have capacity. And if it's determined that they do not have capacity, then they would appoint someone to make decisions for that individual. And in addition, like in Michigan, some states also have the additional requirement of, in addition to finding someone incapacitated, they also have to find that it's necessary. So for example, if you had a power of attorney, it's not necessary because you've already named a decision maker. So, and guardianship is, in some instances, can be a really important way to ensure that people are able to access medical care, to get assistance with managing their bills, those sorts of things. And I think generally people feel like it's sort of well-intentioned and sensible. However, as you mentioned, the team of attorneys that I work with who assist in cases where there's been elder abuse, neglect, or exploitation, we tend to see the cases where that isn't what has happened. And so in addition to those sort of worst case scenarios, guardianship also, because it strips somebody of the rights to make choices for themselves, it can be incredibly dehumanizing. And it has to be, the issue of capacity has to be very carefully looked at because of what an incredible right that is to remove. Like all the things that make up who we are our choices. And so if that is being considered, whether someone lacks capacity or has capacity, you really need to look at less restrictive alternatives first. And so that is something that I think maybe it doesn't happen as frequently as it should. And because the definition of incapacity can be so squishy and amorphous and mean something different to many different people, I think it also, guardianship is a way that people are unjustly stripped of their fundamental basic rights. And so it just has to be very carefully waded into, and you have to carefully look at the motivations of who's filing and what is it for, and who is the right person if it is going to be something that's necessary.
Yeah, certainly it is one of those things that should not be taken lightly, and because it does, as you say, completely strip people of their rights. So in thinking about guardianship and residents of long-term care facilities, in what ways does guardianship control aspects of that resident's life and impact their life while they are a resident.
Yeah, often, obviously we think of the major decisions that guardians make. So they decide what health care a resident would get or whether the resident needs to stay in the nursing home. But guardians, in our experience, also decide the tiniest decisions, whether a person can have a piece of chocolate cake for dessert, what clothes they have to wear, whether they're allowed to participate in activities or go on outings, and really importantly, with whom they can have contact. So sometimes we see guardians in a situation where there's a lot of family tension, and the guardian might decide that the person under guardianship can't have contact with a child or a spouse because the guardian has a problem with that person. So even though I think people normally think of guardians as just making those big and important decisions, they really can control almost every aspect of the person's life. We've had a lot of heartbreaking cases in our office where someone's not allowed to go to the church that they have attended their entire lives or their entire life, or, somebody's not allowed to have a romantic relationship with someone they've fallen in love with in the nursing home. And guardians, unfortunately, if the court has given them authority to make all decisions, are able to interfere with even those most basic aspects of a person's life.
So you've started talking, Alison, about some of the negative impacts that guardianship can have on an individual with respect to some of like the personal choices and decisions. But is it intended, to be that way? Like, should guardians really be able to have such complete control over a person and really say, like, I don't want you to see, a certain family member who might be very important to you?
First of all, not all guardianships have to be full guardianships. If a person only has difficulty making decisions in one area, then really that guardianship should be limited to just that area. But unfortunately, we often see judges just appointing full guardians, in part because it's easier to do that than to decide where the person can make decisions for themselves.
Mm-hmm.
If there is a full guardianship, in many states, that does mean that the guardian is allowed to make those decisions about all aspects of the person's life, because there's nothing in the law that says, well, this is reserved to the person, this choice is reserved to the person no matter what. And that's something we really would like to see changed. But most guardianship laws do have language that the guardian, even though the guardian ultimately makes the decision, the guardian's supposed to consult with the person. The guardian's supposed to honor that person's choices to the greatest extent possible, to make choices that are consistent with the person's life history, and to promote autonomy to the greatest extent possible for the person. Even though that's in a lot of state laws, we often don't see that happening. But when a guardian is making decisions that are totally contrary to the resident's wishes and not legitimate because they're necessary for the person's safety or well-being, that might be a time when we want to go back to court and see if we can get a different guardian or limit the guardian's authority.
Mm-hmm.
One thing I want to add is I also, in addition to stripping someone of their ability to make decisions about those basic things, I just the sense that this person like is no longer, doesn't have personhood in a sense to the folks around them can really affect, even though it's not specific to one choice, it can really affect somebody's quality of life. And so just to give an example of something that we definitely hear happening in long-term care facilities here is, our staff will, just like the ombudsman, go and visit residents for meetings. And if you're asking staff, where is Sally? Can I, which room, where do I go? And it's not uncommon to hear staff sort of talk over where is so-and-so and say, oh, that person's not their own person anymore. And so there are phrases and things in the way that their people are treated where they're sort of talked over or about instead of to, because the stigma of being found incapacitated just in some instances, people just start dismissing them and not including them in any of the conversations, which is incredibly like paternalistic and just is really sad, and it makes people depressed, and their quality of life really plummets because they could feel isolated, like if Alison, like she said, aren't able to access visitors, if they're not eating the things they like, and then everyone's talking about them as a ghost. And actually, guardianship has been referred to as, making someone a legal ghost in a way,
Wow.
because they don't have, none of the things that make them themselves are present anymore, and people treat them like that.
There's studies that say that people who have more autonomy have better health outcomes. So it's not just, certainly we agree with Emily, people feel demeaned and depressed, but actually they also have physical health consequences from not being able to make decisions for themselves and feeling so disempowered.
And I think another important thing that you said is how isolating it can be for someone. And, coming on the other side of the pandemic now, we saw what isolation has done to people, particularly in long-term care facilities, and how that really can negatively impact both physical, mental, and psychosocial health for an individual. And I could certainly see how you would depressed if you're not able to access the people or things that you like the most, or that are important to you. Absolutely. So we know that in some cases, an individual goes into a nursing home without a guardian, but that nursing homes sometimes encourage guardianship either upon admission or after the person comes in. And can you talk a little bit about why you see situations like that, and what factors contribute to that?
Sure. Guardianship is always supposed to be sought for the benefit of the person. But in nursing homes, we often see that there are a lot of other interests that motivate them to pursue guardianship that aren't necessarily primarily about what's best for the person. So some of those situations include they might be tired of dealing with a resident who's outspoken about their wishes, or a family member who is demanding about the quality of care and life the person is experiencing. And they want to find somebody who will be a decision maker who's easier to deal with from their perspective. So they might think, oh, let's get a guardian. And maybe that person will be less troublesome for us to deal with. Sometimes nursing homes pursue guardianship as a mechanism to get an unpaid bill, paid. And guardianship should never be used for the purposes of bill payment and collection. Sometimes a nursing home might be afraid whether or not this is legitimate about their liability. If a person is choosing to go out into the community during the day, even if that puts them at some risk, they have the right to do that. But a nursing home might feel that they'll be liable, that they could somehow be blamed if something happens to the person. So they think that having a guardian who will deny the person the right to go out in the community might somehow protect them. So there are lots of incentives for nursing homes that really don't have anything to do with the person's well-being or the person's needs.
I want to jump in on the debt collection one, because that one to me feels the most sinister in a way. I mean, they're all fairly sinister if you look at them, but I think that one is particularly interesting because oftentimes the reason that it comes up is because somebody maybe wasn't Medicaid eligible for a certain period of time, a bill accumulated. It's not insignificant given the cost of long-term care. So maybe we have like $20,000 or $30,000 of debt. And a lot of times the reason guardianship is pursued is because the individual has a home that they want to return to. So that they can live back in the community that maybe it's a home they've owned for 50 plus years. Their children grew up there. And the nursing home then will see this, this is really the only asset. And so the only way that we're going to get this debt paid is to liquidate that asset. And of course, the children aren't going to be amenable to selling the home typically, nor is the individual who wants to go back and doesn't want to be in the nursing home the remainder of their life. And so a professional guardian is chosen to help liquidate the asset, and then them liquidating the asset, clearing all the things out of, including personal items. A lot of times the ombudsman and the attorneys from my team will be trying to address not having guardians dumpster personal items like photo albums, military flags, that sort of stuff.
Mhm.
And then the guardian, because they're spending time doing that, can also pay themselves from the proceeds of the sale of the home. And so I for anybody that's interested, it's I Care a Lot is a really fun romp of a movie on Netflix, and it's actually based on a scandal in Nevada that had to do with like a corrupt guardianship sort of a ring that did exactly that. They liquidated people's estates to pay themselves and to get the cash. And it's not as uncommon as you would think it would be. I mean,
Mhm.
it's surprising how many of those cases we defend here in Michigan.
And I think, another thing people don't always understand that you alluded to is, so like one would think, for example, that if a guardian were going to be appointed, that you would look at someone close to the person, like a sibling or a child or a spouse or, whatever. That's not necessarily true. And particularly in some of the situations like we're talking about right now, um, the court could appoint anybody, right? And so it could be a professional guardian or someone else who's appointed, not necessarily the person closest to the individual.
And that's an issue that Emily's done a lot of work on here in Michigan because there are often suitable and willing family members, and it's devastating to them when someone else assumes complete control over the person they love, and that professional guardian might have many, many, many other people for whom they're responsible. They might not have any personal knowledge of the individual for whom they're making decisions. And sometimes they can interfere, as we talked about, with communication for with communication with the resident so that the family member is really cut off from the resident. So, in our state, the law says that a professional guardian should be appointed only as a last resort if there is no suitable and available family member, friend, or someone else who really knows the person. But that doesn't always happen. Judges are often eager to just appoint a professional they're familiar with and move on to the next case.
Mhm. So,
Yeah.
Emily, was there something else you wanted to add?
Yeah, I mean, I think if there's any amount of disagreement amongst siblings, it's hard sometimes to untangle what the disagreement is about, and particularly if people are pointing fingers at the other for being the leeching sibling.
Mhm.
But the fact of the matter is, if one of the siblings is somebody that would do right by their, for example, parent, then there's no reason why you should pass over them because there's family conflict. Like that is, we're all human. That's what
Right.
happens. Litigation is stressful. And I think there's just not an appetite to like wade into whatever that conflict is and figure out who would be the best one. And skipping down to the bottom of the line is the easiest thing to do, even if it means potentially having someone, a professional appointed who also has over 100 other people that they're serving, which is really unfortunate.
Mhm. So, I know when we started the conversation today, we have acknowledged and recognized that there are some situations where guardianship is necessary. It's an important tool in order to help support an individual. But we know that there are less restrictive alternatives that should be considered before approaching guardianship, and particularly full guardianship. And so can you talk about what some of those less restrictive alternatives are that could support individuals?
Sure. So the most common less restrictive alternatives are powers of attorney, either powers of attorney for finances or powers of attorney for healthcare. And one thing that we think is really important is that you don't need to have perfect capacity to execute a valid power of attorney. If a resident knows whom they trust and generally what powers they're giving to another person, that might be enough for them if they are consistent about here's the person I trust and here's the person I want making decisions for me. That might be enough, even if they no longer have the capacity to make complicated healthcare or business decisions for themselves. So if a power of attorney is all they need, and that would enable and authorize somebody else to make decisions for them when they can't make them for themselves, it's really a terrible thing if instead they get slapped with a guardian and all their rights are taken away from them. But there are lots of other less restrictive alternatives. Sometimes people end up in the nursing home because they weren't managing well in the community, and people think that's because they lack capacity. But what we found is maybe they just needed home and community-based services. Maybe they just needed public benefits. Maybe there's some other service or support that would enable them to live safely and independently in the community. And it's not that they lack capacity, they just weren't aware of or couldn't access the kind of help that they needed to be safe. So there's a whole array of services and benefits that might be able to help. And then there's been a lot of talk recently about supported decision making, where people can make decisions, but they just need help, like we all do sometimes, in understanding the consequences of their decisions and the options that are available. And they can have a really trusted support group that helps them think through decisions and come to a decision that's really, well-reasoned and thoughtful. Emily probably can think of a million other alternatives as well, because there are lots of them. But that's one thing we just say, people should think really broadly about that. There's not a single less restrictive alternative. Depending on the circumstances, a wide range of them.
Yeah, I mean, and I think as people are looking at what kind of supports do people need, they should be tailored for the individual. It's not a one size fits all situation. And so, just because a person may need help managing their finances doesn't mean you need to go after complete guardianship, which strips a person of all of their rights. So, looking at how you can tailor and provide support for the assistance that the person specifically needs is certainly one of those issues. Alison, you and I have done some work around some interim incapacity, that has taken place with individuals as they, transfer from a hospital to a nursing home, for example, and how people often get caught up in the guardianship system when they've suffered a health event, and the capacity might not be a permanent incapacity, but a temporary one. Could you just touch on that a little bit? And
Sure. And it's a really important point, because sometimes people, when they're in the hospital after a tremendous health crisis, do lack capacity, but it's not necessarily something that's going to be permanent. They might completely regain their ability to make decisions for themselves. Unfortunately, once they get caught in the guardianship system, it's often, as our Attorney General says, a highway without an exit ramp. I always say, if it's a game of chutes and ladders, it's all chutes and no ladders. So once people get stuck in that system, it's unusual for someone to go back and look at them and think, wait a minute, have they gotten better? Do they still need this really restrictive arrangement? So, one thing we talk about a lot here is it's just as important to learn about how to modify or terminate a guardianship as it is to figure out how to get a guardianship for someone. People's needs and abilities change all the time, and we should be thinking about the legal structure that they're in changing too. As you said, it's got to focus on the individual circumstances the person's in.
The other thing actually that we see in our cases as well is if a guardian is appointed, oftentimes depending on, again, their motivations, if they feel, for example, if it's an adult child and they feel so much more comfortable that their parent is in a nursing facility and they have their needs met, they're not at home, they're not worrying about them, then that individual, whether it's out of just concern for their parent, or maybe it's something a little bit more manipulative, may also continue to indicate to physicians and anybody that the client is interacting with that their parent continues to lack capacity even when they really don't. And so we have had, I actually just finished litigating a case where there was a lot of manipulation of medical records, and my client was an artist. She was very freewheeling. She was a potter, so she always had pottery. She is a pottery all over the place, and she was just kind of messy. But it wasn't unsafe. It was just part of the way she'd always been. But that became hoarding. And so there's certain words that the fiduciary was using to take things that were very unproblematic and just part of my client's being. And those ended up then in medical records, which are then reviewed. And then another physician is meeting with the client and sees the word hoarding. And then suddenly the medical records don't actually support or reflect my client in any way. And so litigating against something like that to try to terminate or modify a guardianship gets very tricky and complicated. And in Michigan, one of the mechanisms we have is the client can request an independent medical evaluation, which is great, but they're very expensive. They're thousands of dollars. And so that's not an option for everybody. Thankfully, it's a litigation expense we can cover for clients. But if you don't have that availability and you're working against medical records that are not indicative of what your capacity is, that can be really hard to get out of.
Yeah, absolutely critical things to consider, and again, some of the dangers, of guardianship and what happens when a person is put under guardianship. I've listened to presentations that you've given, and you've shared some questions to consider in the past, when guardianship maybe is being, considered, and some of them, and I pulled them up as like, is there a problem? Will guardianship solve the problem that's identified, or is there a less restrictive way to solve it? And I think that, that's really key to, thinking about, whether guardianship is the most appropriate option for this particular situation and this particular individual. So thinking about those questions is really important. So is there a pathway for residents to regain autonomy once under guardianship, and what would that look like?
Absolutely. You can always petition to modify or terminate the guardianship. But to do that, it's not always easy. It really helps to have a lawyer. But even people who don't have lawyers in most states, or maybe all states, have the opportunity to informally approach the court and say that they don't think they need a guardian anymore, or they want a different guardian or a less restrictive guardianship. If you're going to try and change or end a guardianship, it's really important to have allies. And those allies could be nursing home staff who believe that the resident has regained capacity, doctors, friends, family. An ombudsman is always a really good place to start, because the ombudsman generally can help the person think through what the options are, how to connect to legal services, whether sometimes ombudsman will be familiar with how the person might be able to approach the court, and help the person think through, who are my allies here? Who will speak up for me? And how do I organize them so that the judge sees I really don't need a guardian anymore? One of the best situations is if the guardian himself or herself says, you know what, I don't think this person needs a guardianship. And that goes a long way to persuading judges that the guardianship should be changed or ended. And one really important thing is that the resident tells everyone and says loudly and clearly, I don't want a guardianship. I don't need a guardianship. There's often a court investigator who looks at these cases, and it's really important for the resident not to be shy, but to be really bold about and loud and clear about what they want and what they think they need or don't need.
We've heard some situations where residents have been denied access to either ombudsman or attorneys, particularly legal services attorneys, if they are already under guardianship. Can you talk about that a little bit, what your experience has been with that?
I actually just had a case that was just like this. One of the problems if someone has a guardian is that, we talked about before, like, what can the guardian decide? What are the limits, right? And I think there's misunderstanding, particularly with a guardian who's particularly controlling. What do I get to do when I am controlling the visitors for this person? And the case that we just had, the fiduciary was very controlling, didn't want the client to have visitors. That included friends. Police were called when friends came to visit. And so this extended then when the ombudsman connected the client with the legal services attorney. The legal services attorney spoke with the client, assessed that she had absolutely had capacity, and was working towards trying to assist the client in regaining autonomy and remove the fiduciary. But the police were called again when the ombudsman and the legal services attorney showed up. And unfortunately, the nursing facility, participated in that. They didn't say, stop, like this person, there's actually a law that says you cannot prevent a long-term care ombudsman from accessing or residents from accessing ombudsman. So the fact that the ombudsman was asked to leave by the police was quite a brain twister, but that does happen. And thankfully, after it happened, it was a huge education campaign. How can we talk to the facility so that this doesn't happen again? This person has the right to have access to an attorney, absolutely has the right to have access to an ombudsman to help advocate on their behalf. And so it's incredibly frustrating, but I also love that there's programs like Alison's that engage in that constant advocacy and just making sure that the facilities are aware of what the rights of residents are so that they aren't totally isolated from assistance. Because if they have absolutely no voice to challenge the guardianship, then how will they ever be able to get out of it? And a lot of our clients don't have access to technology. They may not have a cell phone. They may not have a computer, which this client did not. So the only way that they could talk to somebody is when the ombudsman comes in and pops by their room and asks how they're doing. And the ombudsman is their connection to the legal services world. Also, I'm happy to report that that client no longer has that fiduciary and has absolutely had all of her rights reinstated, which is wonderful.
And in that case, we have to educate the police too.
Yes, absolutely. That's a good point. Which happened and they said they wouldn't do it again. So that's great. There was a lot of education of both the nursing facility, police, and the client as well, so that she knew to also speak up and put her foot down. And I'm happy to say that now the client no longer has that fiduciary. She has autonomy. She's actually left and gone home. So she texted me the other day and said, I'm sleeping in my bed. It's so comfortable. I love it. But when someone doesn't have access to a phone or a computer, the only way that they can access a legal services attorney potentially is when the ombudsman comes and knocks on their door and says, hey, how you doing? Is there anything you want to talk to me about? Because they can't go to the front desk and ask to use the phone to say hey, I'm being trapped here by a rogue fiduciary. And I'm afraid that they'll call the police if I say anything, because they're sitting right there and listening in on the conversation.
Right. So it's important to, recognize that residents do have the right to access the ombudsman and to ask for help in these situations, and to get the legal support that they need to get out from under guardianship, or to get the help to try to do that if necessary. So I do think, go ahead, Alison.
Oh, I'm sorry. I was just going to say that I know ombudsmen are often frustrated when, for example, the resident wants to return to the community and the guardian says absolutely not. And sometimes that sort of ends the inquiry for the ombudsman. They're, really sad to have to tell the resident, I'm sorry, that's not going to happen. Your guardian says no. But I do think that there should be one more inquiry in. That inquiry should be, does this person still need a guardian? Or is this the right guardian? And is there a way we can address the residents' wishes by just changing this guardianship situation? So it is really difficult to be an ombudsman and be faced with a recalcitrant guardian, but sometimes the ombudsman can be really critical in helping to change that situation so the person can get what they want and can either have no guardian at all or a guardian that really supports them and helps empower them.
Mm-hmm.
I'd like to add one thing to that as well. I think that a lot of people are guardians not because they were trying to be controlling of people's lives. A lot of guardians are good intentioned, and I think that one of the things that our staff has started to try to do, and that I think we could do more of as well, is just if the person does need a guardian, because some clients do, but their wishes are not being valued and listened to, you can still petition the court to say, I want to go home. I don't want to live here. I'd like the guardian by court order to be required to explore that and help make that transition home. And so even if the guardian remains, there's still ways to have the court intervene to make sure that that client's desires are honored. And I don't, maybe more of a dialogue with guardians would allow that would be like something that would help them think about it maybe in the next case too, and pushing the envelope a little bit and I think in a way that could help legal services and guardians team up, because legal services attorneys understand home and community-based services, and what if, like, how can we access various benefits? And it would be nice to be able to have that to be a connection instead of adversarial. I think that's possible too.
I really agree with that. I think that often guardians who are making decisions that we perceive as overly restrictive or wrong are just not educated about the damage that it can do to people to have their rights so restricted, about the fact that there are alternatives. And so I completely agree with Emily. A lot of what we have to do is not fight, but educate. We're always up for a good fight, but we're also really, really happy to educate people and open their eyes to the fact that there are lots of alternatives and there might be a better way to help the person they really do care about.
And I think that also goes to, one of the questions we had listed for today is how to also help preserve the residents' autonomy, within the guardianship system. And I think what you just both said applies across the board to all of the decisions that a resident may want, really looking at their preferences, how to make this as individual as possible in terms of honoring a person's wishes, preferences, not only with respect to where they live and who they're working with, but all aspects of their life, even if it is wanting to have that piece of chocolate cake for dessert, which you alluded to at the very beginning as one of the examples. So, I think this was a really important conversation, and thank you both so much for the great tips and strategies that you've shared today, and certainly a lot of food for thought, I think, for people who are listening to the podcast today. It's a discussion that I hope we can continue to have. And for more information for our listeners on guardianship issues and other long-term care and advocacy issues, you can go to our website at www.theconsumervoice.org. And thanks both to Alison and Emily for being with us today.
Always a pleasure to talk to you, Lori. Thank you.
Thanks. With that, we'll close for today. Have a good rest of the day, everyone.
Thanks for joining us on Pursuing Quality Long-Term Care. This podcast is a program of the National Consumer Voice for Quality Long-Term Care. Make sure to visit our website, theconsumervoice.org/pursuingquality, where you can subscribe to the podcast, follow us on Facebook and Twitter, and find more information and resources. If you enjoy the podcast, please rate, review, and subscribe. Thank you for listening, and we'll see you next episode.